Here's a segment from a recent Gun Talk radio episode. You can listen to all the Gun Talk radio podcasts however you tune in, or check out guntalk.com for more. Crazy stories, crazy things going on in the courts. And look, I have been saying this from the very beginning. From the moment the Supreme Court gave us the Bruin decision, which changed the landscape, changed the methodology for analyzing gun control laws. The environment has changed. The legal environment has changed, especially at the Supreme Court. We have 3 cases, maybe 4. It is hard for me to keep up. We've got, in the Fifth Circuit, Cam Edwards is right. He says, really, we should just be talking about now it's the Fifth Circuit versus the ATF. The appellate court already shot down the Trump administration's ban on bump stocks on the merits. A U.S. district judge in the Fifth Circuit's jurisdiction, I don't know if you caught this one, granted a nationwide injunction this past week against the ATF's rule that defines brace-equipped pistols as short barrel rifles. In other words, the ATF adopted a rule that said, pistol braces, they were okay before, but now they're not. And if you own one, you could be arrested and charged as a felon. Yeah, not anymore. That's gone. That is gone. Now, if the government appeals this to the Supreme Court, we'll take another look at that. But as of this moment, the judges ruled that across the nation, this rule is gone. Pistol braces are legal again. This is not one of those where there's a stay where you have to say, well, we're going to have to wait and see how this goes. They're not going to enforce this ruling. No, it's enforced. This is gone. And look, there are a lot of companies that made almost their entire revenue out of pistol braces. They were facing bankruptcy. There are big companies, big gun companies that made millions and millions of dollars selling pistol braces and pistol-braced firearms with braces on their handguns. This could and probably will return that revenue stream to them. Now, we'll see. I kind of expect that the government will appeal this, that the Department of Justice will appeal this to the Supreme Court. The Supreme Court will probably take it, and the Supreme Court will probably almost certainly rule against the ATF, because that's kind of how it's going right now. These cases, bump stock, pistol brace, and then the one that just happened like 3 days ago, the Fifth Circuit determined that the agency, the ATF's rule, declaring that unfinished frames and receivers should be treated as though they're already firearms. Yeah, that's gone. They said, no, that's unconstitutional. You can't do that. You don't have the power to do that. Congress never gave you the ability to do that. You're making up laws, and you can't do that. The court actually said the ATF's rule flouts clear statutory text and exceeds the legislatively imposed limits on agency authority in the name of public policy. We know what was going on here. Biden made promises. He made promises to the gun ban industry. He made promises to the gun ban lobby. He made promises to gun banners who gave him money and gave him support to get him elected. And he said, don't you worry, I got you back. We will put in a bunch of these things that you want. And then, of course, they pushed it down through the ATF, which has no legislative ability, which has no ability to redefine anything that is statutorily defined. It's up to Congress to make the laws. And, of course, agencies have been doing this all along for many, many years. And the Supreme Court is starting to look at that and go, no, EPA, you don't have the ability to do that. They said especially you can't make regulations that have the weight of law, that have the weight of criminal penalties that can send people to prison when there's no such law. I am hopeful that this is just the start of this trend of the court saying to the agencies, no. You don't get to do that. You want it to be a law? Pass a law. I mean, in reality, different subject matter, very controversial. But on the whole abortion issue, that's all the Supreme Court said when they struck down Roe. They said, this is not a law. If you want it to be a law, go pass a law. We're not saying it's good. We're not saying it's bad. We're just saying nobody passed a law to this. This was a decision made by the Supreme Court that had the weight of law, and it did not have that ability to do that. You got to go pass a law. Simple. You want it to be a law? Go pass a law. Fine. And that's what they're saying now. ATF, this is not a law. You don't get to decide it is. You don't get to decide to ban these things when the law as written by the United States Congress does not say this. A lot of things going on right now. And then last week, I listened in on the whole thing, recorded the whole thing. The U.S. Supreme Court heard the arguments in the case of Rahimi. And we've been talking about this for a while. This is the one that the U.S. Attorney General, Merrick Garland, really wanted to get before the Supreme Court because it's a particularly bad case for gun rights. Rahimi was charged with having a gun while he was under a domestic violence restraining order. That's against the law. Question is, that's not due process. No one was convicted of anything. You've simply been accused of something. Do you lose your constitutional rights on the basis of that? The problem with the case is Rahimi is a particularly bad dude. He has hurt a lot of people. He's a criminal. And he needs to be in jail. He needs to be in prison for a long time. So as I listened to the case, it kind of went sideways. And I got to tell you, honestly, I don't think the lawyer representing Rahimi, representing the Second Amendment side of things, did a particularly good job. The legal people who look at this, Second Amendment scholars who listen to it, their opinion generally is that they think the Supreme Court will rule against Rahimi, this guy, but will do so in such a way that they spell out that there are Second Amendment protections against losing your constitutional rights on the basis of an accusation, on the basis of a restraining order. We'll just see. It's very possible, this kind of gets into the weeds, but it's worth paying attention to. There's another case called Range. And it's entirely possible the Supreme Court will take the Range case, will combine it with Rahimi, because Range is very interesting. This guy is denied his Second Amendment rights, Range, because he was convicted of lying to get food stamps. And because that had a potential, he never served a day in jail, but that had the potential of sending him to jail for more than a year. That means he is prohibited for life from having a gun under the felons don't get to have guns law. So the Range case is going to be very interesting to watch, see if that gets to the Supreme Court. Do they combine it with Rahimi? I don't know. All kind of crazy stuff.